We are extremely pleased with the Supreme Court of Canada's decision confirming the unconstitutionality of the federal government's Destructive Impact Assessment Act.
The Supreme Court of Canada ruled today that the federal government's environmental impact law was largely unconstitutional. Now, this is the act that gives the federal government the power to trump big projects such as coal mines or oil sands projects if it deems they are not in the public interest. Jonathan Wilkinson is Canada's Minister of Energy and Natural Resources. Minister Wilkinson, welcome back to the show.
Thank you very much.
So you said that the concerns brought forward in the decision can be dealt with in a relatively surgical way. So what does that look like?
Well, first I will say the ruling came down today, so we need to make take the appropriate time to digest it. But we will need to make some amendments to the act. We intend to develop those over the coming weeks. Certainly, I think it's important that we try to do this in an expeditious way, and we will need to bring those back and essentially bring them through the House and through the Senate.
So there are currently 32 projects winding through the assessment process. Where does this leave those projects right now?
Well, those will continue through the process. Obviously, we will be very focused on ensuring that the Impact Assessment Agency, which is the agency that essentially monitors these, is in their assessment focused very much on impacts in areas of federal jurisdiction. As I say, that is the way in which the agency has worked from the beginning anyway, but we will certainly ensure that because that is what the court has asked us to do. But I don't anticipate there being significant impacts on projects that are already moving through. But as I say, to ensure that there is clarity and greater certainty, we will be expeditious in terms of how we manage the amendments.
There are people in industry who have long been frustrated by what they say are the opportunity costs lost on this because of what they call your government's failure to ensure the constitutionality of this process. What do you say to them?
Well, I say to them that, we spent a couple of years developing this act to try to ensure that we actually got it right. Prior to the Harper government had gutted environmental assessment legislation, we had lost the ability to actually achieve any level of consensus because nobody trusted the system and nobody trusted that government on environmental issues nor on the respect for Indigenous rights. So we tried to come up with a system that would actually ensure that through an assessment of impacts on federal jurisdiction, that those issues were being considered early on and addressed so the good projects could move much more quickly. And we will have to go back and make some amendments to ensure that it's clear that we are focused on areas of federal jurisdiction in a federation. That's a reasonable thing to do. But I would say that the process itself actually has been working. I mean, there was an LNG project that went through the process, a BC LNG project that went through the process in less than 3 years. You would never have seen that with the Harper process.
But we have a situation now. We're going to speak with Alberta Premier Danielle Smith about this later in the show. This challenge started with former Alberta Premier Jason Kenney. They've long argued that this is federal overreach, and today I guess they've been handed. Right. So what do you say to them?
Well, I say to them that the act itself, the court has decided that we need to go back and ensure that it is much more closely tethered to areas of federal jurisdiction. But I want to be clear, areas of federal jurisdiction include greenhouse gas emissions, as was upheld by the Supreme Court of Canada. They include fish and fish habitat, so most of the water bodies in Canada. It includes species at risk, and there are almost 700 of those across the country. It includes migratory birds, and it includes respect for the rights of Indigenous peoples. And that the court has upheld that those are legitimate areas for the federal government to continue to play a role. So Premier Smith can say whatever she wants in terms of this being a great victory for the provinces. But at the end of the day, we have never endeavored to interfere with areas that are clearly provincial jurisdiction. But things like greenhouse gas emissions are not.
Right.
And I think that the provinces like Alberta and Saskatchewan need to be very careful about how they interpret this ruling.
No, and we know the Supreme Court has ruled on greenhouse gas emissions in the challenge of carbon pricing and the carbon tax policy. But this sort of deals with this at the Supreme Court, this particular debate. But Justice Wagner wrote about how environmental protection remains one of today's most pressing challenges. So how does this affect your environmental agenda and your protection plans that are part of that?
Well, as I say, the environmental agenda, there's kind of a number of components. One is conservation, and we will continue on with the conservation agenda to achieve the 30 by 30 protection targets that must happen around the world if we're going to stop the decline in global biodiversity. we will continue to move forward with respect to the climate agenda, and that's something that, as you said, the court has upheld. When Premier Smith talks about federal overreach, I would be curious to dig into exactly what she means by that, because at the end of the day, if what she means is the federal government has no role to play with respect to regulating greenhouse gas emissions and achievement of Canada's climate targets, I would just say to her, I don't think that's the right interpretation.
Minister Jonathan Wilkinson, thank you for your time.
Thank you.
Well, this case is, of course, a big win for Alberta, the province that launched this constitutional challenge. For more reaction to the Supreme Court decision, I'm joined now by Alberta Premier Danielle Smith. Premier Smith, welcome back to the show.
My pleasure.
Your predecessor, Jason Kenney, long opponents of this legislation. What's your reaction to what the Supreme Court has had to say?
Well, it's a clear victory for provincial rights. It means that the Constitution actually matters, that we have areas that are defined under Section 92. And in the Constitution, it says we've got the exclusive jurisdiction to develop our resources in our own way, as well as develop electricity. And we intend to make sure that the federal government honors the spirit and the letter of the decision today and back down on some of the legislation that they've been trying to foist on us for many years. I think the sad part is they act in an illegal way, an unconstitutional way, and then they make us go to court for 6 years to be able to get our rights back. But I'm pleased to see that the Supreme Court made the right decision today.
We've just spoken with Natural Resources Minister Jonathan Wilkinson, and he argues that in spite of this decision, they've enforced and interpreted the Act broadly in compliance with the spirit of this decision, and they think there's a path forward with amendments and changes to the law that they can still move ahead with this legislation. What do you think is going to happen there?
Well, the amendments they need to make is to stop trying to interfere in provincial jurisdiction. The court was very clear that the federal government does have constitutional authority over cross-border projects. If you're building a pipeline or transmission line that goes cross-border between provinces or even down into the United States, I've always acknowledged that they have the right to be able to make those decisions. But they do not have the right to tell us that we can or cannot build power plants, that we can or cannot build roads, that we can or cannot develop our resources. That's where they've drawn the line. And I would hope that the federal government would respect that. It's been a very clear ruling that any major industrial project solely within the boundaries of an individual province are to the province to provide the regulatory oversight, not the federal government. And they need to respect that decision and not try to find any kind of weasel words to be able to try to maintain unconstitutional legislation, because we won't stand for it.
Well, what they're saying is obviously they will abide by this, by the Supreme Court, and amend the legislation to bring it into compliance. But they're still insistent that the earlier Supreme Court ruling on the challenge of the carbon tax does give them the right to regulate greenhouse gas emissions. Nothing changes on that front. So there could be collision between that right and the ones that have been preserved in here. I see you shaking your head. Why?
Yeah, you bet there'll be collision, because any emissions cap that is unreasonable, unrealistic, where the technology doesn't exist, that is too aggressive, is a production cap. And a production cap is a clear violation of our right to be able to develop our resources. Same thing with electricity. We have to be able to keep our lights on. We have to be able to ensure reliability and affordability, and we will assert that right. Where we'll work with the federal government is, as we always have said, from the very first conversation I had with the Prime Minister, aligning around a 2050 carbon neutrality target. And that's what they should be coming to the table with, is working with us in our areas of jurisdiction to be able to achieve that joint goal. And if they do that, then I don't think there'll be a need for any more court decisions, but we will defend vigorously the rights that the Supreme Court acknowledged today.
So obviously, look, there's still going to be some issues to be sorted out between you and the federal government. I think that's a safe assumption to say here. But what projects or plans that you have on the books right now that you felt couldn't go ahead under this existing framework may be able to go ahead now that we have this decision from the Supreme Court?
Well, I can tell you that they've created so much uncertainty in our electricity grid. We're a natural gas basin, and most of our natural gas, most of our power grid right now is fueled by natural gas. And yet I have no natural gas projects in the queue because they created so much uncertainty over how those projects can go forward and be approved. As a result, we're now having periodic times where our power grid has been near failure. We've had 8 times this year where it's been near failure. So we are going to go ahead and commission baseload power so that we can keep the lights on. That would be one example. Another example was the Tech Frontier mine from years ago. It was a $20.6 billion project that got shelved because they couldn't navigate through the regulatory process. If they want to resurrect that project, knowing that we have the regulatory approval to go ahead with it, we'd be more than happy to reconsider that. Those are the kind of things that we'll be looking for. I'm sending the message, Alberta's open for business. We have a 2050 emissions reduction target we will work with the federal government on, but we're going to be approving projects.
But I can see this obvious collision coming now, because while this decision does change the federal role in project approval, nothing today changes their ability to regulate greenhouse gas emissions across the country. That has clearly been decided by the Supreme Court of Canada. So I know you say they need to sort of butt out of your plans, but there's still a clear, legally Supreme Court validated role for Ottawa to play in this.
Well, we have an emissions reduction plan. We were the first to bring in industrial carbon pricing. We were the first to develop carbon capture, utilization, and storage. We set a target to reduce methane emissions 45%, and we achieved it. We have an emissions reduction and energy development plan that takes us to 2050. We have an MOU with different jurisdictions on small modular nuclear. We're developing out a hydrogen economy. We're being a responsible player in Confederation. We're respecting that we have to reduce emissions, but we're going to do it our way. We're going to do it in a way that allows for us to continue to develop our resources, which we have a constitutional right to do, as the court affirmed today.
Right, and just as a final point, can you really just do it your way? I mean, don't you have to do this at least in some sort of conjunction with the federal government? You keep asking them to respect your rights, but the court has ruled they have a role here. I mean, don't you also have to respect their rights and their ambitions in this?
Well, as I said, I told Prime Minister Trudeau the very first call I had that I would be happy to work with him on a 2050 target. We developed our emissions reduction plan. I asked him to wait for it. He did. We did abatement curves so that we could figure out how quickly we could get to 2050. That work has been completed. I asked for us to have a table where we could get together and talk about how we would align our targets. I've been very constructive, and I'm going to continue to be constructive, but they cannot act unilaterally. That's what the Supreme Court said today. They cannot act unilaterally in our area of jurisdiction, and we're going to make sure that they uphold the spirit of what the court decided today.
Doesn't that same argument apply that you also can't act unilaterally when it comes to things like greenhouse gas emissions?
Well, I'm not trying to interfere in their ability to manage cross-border pipelines or cross-border transmission lines.
But emissions.
So I would say, well, look, I mean, this joint jurisdiction. Anytime you have an emissions cap that is a production cap, they collide with our rights, and we're just going to make sure that doesn't happen.
Okay, Alberta Premier Danielle Smith, we always appreciate the time. Thanks for joining us.
You bet. Thanks, David.